Welcome, everyone. My name is Andrew, the founder and owner of Ibis Prep, and today we are going to do a lecture on four essay subjects, technically six essay subjects, because con law is really in three parts: federal con law, Florida con law, and con crim law, and then real property, ethics, and family law. Um, you know, I don't really like to play the numbers game. I don't like to give myself a chance of failing. So I don't really like to say this subject is going to be tested, this subject is not going to be tested. I like to say master it all. Put yourself in position to pass the test that no matter what's tested, you really feel strongly that you can do well on it. So let's go over everything from the start. Um, First thing would be federal con law. When it comes to federal con law, um, really First Amendment, Fifth Amendment, and 14th Amendment are pretty heavily tested. The First Amendment, you think of like the freedom of speech, the freedom of religion, the freedom of petition, the freedom of assembly, and the freedom of press, right? These are the guarantees of the First Amendment. What's most heavily tested would certainly be the freedom of speech, right? That the government cannot restrict your freedom to speak openly, right? And how that could come about would be if there's a restriction, some law or ordinance that says that people are not allowed to talk about, who's their favorite candidate in a public park or on the sidewalk, right? That's a public forum and it's a content-based restriction. So that would be subject to strict scrutiny. And the scrutiny levels are important. There's strict scrutiny, intermediate scrutiny, and then rational basis. And you want to know the terminology. If we're going to use strict scrutiny, the government needs to show that the regulation or ordinance is necessary to achieve a compelling government interest and it's narrowly tailored to that means, right? So necessary, compelling interest, narrowly tailored, right? That's content based. Where if it's a content neutral restriction, it's more or less a heightened version of intermediate scrutiny, right? Where it needs to be an important government interest, right? Substantially related to an important government interest. Um, and it doesn't need to be compelling, but it needs to be important. And when we think of a content neutral, we're thinking of a time, place, and manner restriction. So that's kind of the first place where you should start your federal con law understanding is First Amendment, freedom of speech, content-based versus content neutral restrictions, and understanding the different scrutiny levels that are applied. And, if it's something that's going to impact a fundamental right, we're going to trigger strict scrutiny. So that's the first part of the First Amendment is freedom of speech. There are certain types of speech that are not protected under the First Amendment. Does anyone know any of those types of speech that are not protected, that don't receive strict scrutiny or protection? Yeah, hate speech is a good one, right? That one's come up recently. Usually hate speech in the unprotected sense is directed towards a particular race, religion, or sexual orientation, right? Yeah, incitement to violence, right? Words that are likely to incite imminent lawless activity, right? Like yelling fire in a movie theater and then everyone starts trampling out and acting lawlessly. Yeah, obscenity. Sure, obscenity is not protected, and obscenity is interesting because the definition is words that appeal to the prurient interest of humankind and are devoid of any artistic or literary value. So, most things are not obscene, right? Just because something is profane doesn't mean that it's necessarily obscene. Yes, someone saying false or misleading commercial speech, right? That's not going to receive constitutional protection because it's you know, getting people to purchase things that in an untruthful way. Any others that you can think of besides obscenity, false or misleading commercial speech, words that are likely to incite imminent loss activity, hate speech? What about a tort that's a type of speech that's not protected because it actually amounts to tortious activity? It's an interesting way of putting it, but a type of speech that could actually lead to civil liability if you say something that injures another's reputation. What's that type of speech called? Yeah, Andres saying and Melissa saying slander per se, defamation, right? I'm thinking defamation, slander, libel. It's not going to receive that strict constitutional protection, right? So these are all some ideas to think about with the First Amendment, freedom of speech, right? And then freedom of religion, we think about the Establishment Clause and the Free Exercise Clause, meaning that um, you have the right to establish a religion if it's a sincerely held belief, and you have the right to freely exercise your religion as well. Um, the Supreme Court has abrogated the traditional lemon test, so now we just kind of look at, traditional concepts of liberty when it comes to religion. But you could see if there's like a public school that's forcing everyone to adhere to a specific religion, then that would likely be problematic as a violation of establishment or exercise. Um, Honestly, someone's asking, do we still use lemon in Florida? The answer is unclear because the Supreme Court has overturned that case. So, some jurisdictions in Florida might still um, reference it, but it's not prevailing law at the top of the totem pole, let's say. So, I wouldn't, recommend uh, incorporating that analysis, right? But it still could be useful in argument. But according to the Supreme Court, yeah, that there's a more of a relaxed outlook towards the separation of church and state. But again, just some key concepts from the First Amendment: freedom of speech and freedom of religion, and then also freedom of press, freedom of petition, freedom of assembly, and then certainly understanding, strict scrutiny, intermediate scrutiny, and rational basis, and content based versus content neutral. Content neutral being time, place, and manner restrictions. So there's some of the key concepts from the First Amendment. Then I also mentioned the Fifth Amendment, and I'll talk about the Fifth Amendment too when we do the con crim analysis. But how I remember it, just like there's five things from the First Amendment, right? Freedom of speech, freedom of religion, freedom of press, freedom of petition, freedom of assembly. There's also five things more or less that are protected by the Fifth Amendment. The first one would be due process, right? Procedural and substantive due process. That's definitely a major protection from the Fifth Amendment. Then we also have this idea of the takings clause, eminent domain, where the government needs to provide just compensation if they're going to take private property, or you could think of a uh, regulatory taking, which is different than a possessory taking. A possessory taking is when the government actually takes the land, they seize the land for public use, whereas a regulatory taking is when some rule, act, or ordinance, some law renders the land um, economically useless, right? It deprives the owner of their investment-backed expectations, and it renders the land unviable. So, if there's a law in Florida that says you're not allowed to grow oranges, a lot of farmers would be able to claim that there's been a regulatory taking because the reason that they purchased their land was to grow oranges, right? So we have the due process consideration, we have the takings clause. Another one is the right against self-incrimination, which applies to civil and criminal cases. People recommended me to watch this TV show Suits. Finally got around to doing it, and by like the fourth episode, I was annoyed. I mean, I was annoyed from the first episode. I was like, this would never happen in real life. This person would get found out immediately, right? You can't just practice law without a license for a major firm. Like, no, zero chance that would fly. But the other part that bothered me is like this guy Harvey Specter was trying to act all smart, and he was like, someone said I plead the fifth. And they're like, oh, you can't. Specter was like, you can't do that. You can only plead the fifth in criminal cases. Not true. I was like, they're just uh, lying to the people here, right? You can plead the fifth in civil and criminal cases. The distinction is presumptions can't be made in criminal cases where they can in civil cases, but you could plead the fifth. The pleading the fifth is your right against self-incrimination. So that's key concepts from the Fifth Amendment, right? I said due process, I said the takings clause, the right against self-incrimination. Another one, and we'll talk about this when we do con crim, is the right against double jeopardy, right? You can't be charged with the same crime twice, more or less, right? And on top of that, we have the Miranda rights, right? Your right to an attorney. And I'll talk more about those parts of the Fifth Amendment when I do con crim. But just in general, if you're taking some things away from today's lecture, five things on the First Amendment: freedom of speech, freedom of religion, freedom of the press, freedom of petition, freedom of assembly. And then five things from the Fifth Amendment are due process, the takings clause, the right against self-incrimination, the right against double jeopardy, and your Miranda rights, your rights to an attorney when you're in custody. So First Amendment's pretty heavily tested, Fifth Amendment's pretty heavily tested, and then the 14th Amendment would also have some strong implications. Whereas the Fifth Amendment it applies due process, federally, the 14th Amendment applies it to the states, right? And specifically, the 14th Amendment mentions equal protection. So, what's the difference between substantive due process and equal protection? Well, substantive due process is when everyone's rights have been violated. There's a constitutional deprivation of substantive rights. Equal protection is when there's a targeted class, right? Like a specific group of people who are having their rights deprived. And again, you're going to think about strict scrutiny, intermediate scrutiny, or rational basis based on what type of group is being persecuted or targeted. If it's a race, alienage, national origin, um, or First Amendment fundamental rights like contraception, marriage, procreation, the right to direct the education of your child, or your family relations. These are gonna trigger strict scrutiny. Um, Intermediate scrutiny uh, is usually reserved for gender or illegitimacy. And then rational basis is for everything else. Rational basis means that the plaintiff has the burden of showing that the regulation is not reasonably or rationally related to a legitimate government purpose. So it's a pretty easy burden for the government to overcome, whereas strict scrutiny, the burden's on the government. Intermediate scrutiny, the burden's on the government. And that's more difficult to overcome. So, pretty much when you get a con law essay, you can expect to talk about some First Amendment, some fundamental right. You can expect to talk about due process, right? If it's procedural, which would be they need a notice and hearing, right, before they can have their rights deprived, and then substantive due process, meaning that there's been some sort of um, government deprivation of rights. So, fundamental rights, due process, and then equal protection. These are things that are very frequently tested, and you definitely want to make sure you know how to write about them. Um, some other things that they could potentially talk about would be like the Commerce Clause, rarely but potentially, or the Anti-Commandeering Clause. And this would only be the case if they were talking about Congress, right? Like the federal government enacts some legislation. Well, maybe it's valid under the Commerce Clause because it regulates the channels, instrumentalities, and economic activities that in an aggregate have a substantial effect on interstate commerce. Or maybe it implicates the dormant commerce clause where, Florida is trying to enact a law or regulation that would unduly burden interstate commerce. And then the anti-commandeering clause, meaning like if Congress is trying to force the state to enact a law, then that would be a violation of the dormant commerce clause. Those aren't as heavily tested as the main ones that I talked about, but really important concepts to understand. So, when you have a con law essay, they're usually going to give you some act or ordinance, and then it's going to be your job to question its constitutionality. And you could use that federal lens to be like, this is the federal constitution, First Amendment, Fifth Amendment, 14th Amendment, or, whatever it may be, and you're going to start there, right? And definitely with the scrutiny levels, they're pretty heavily tested, right? So you want to have a good idea of how to write about them, especially freedom of speech. I think that that one comes up a lot, right? The content-based versus content-neutral restrictions. Um, the Florida lens, you know, there's a lot of things that could be tested. I think the two most interesting ones or frequently tested ones for especially people who are not from Florida and have to learn them would be the Sunshine Law and the homestead exemption. The Sunshine Law is this right of access to public proceedings and records where, I mean, to governmental proceedings and records where the public has a right of access. All government activity is to be done in the sunshine. So if there's some secret meeting amongst the legislators and it's not recorded and there's no public access, that would be a potential violation of the Sunshine Law, right? Um, the homestead exemption, I mean, it's pretty complicated because there's a tax consideration of the homestead exemption, but the way that they typically test the homestead exemption is the fact that Florida residents, their primary residence is protected from outside creditors. There are certain, creditors that can pierce the homestead exemption, like the government, right? Government taxes and judgments, and also um, liens on the property, right? Construction liens, mechanics liens, or like a homeowners association fee, or maybe a lawyer fee for, procuring or protecting the homestead, right? These are actually related to the property themselves, and that could be a time where that homestead exemption could be pierced. Now, it also protects the spouse and the children, right? They have this homestead protection as well. So those are two of the first, fundamental concepts when it comes to the Florida constitutional lens would be homestead exemption and sunshine law. And you should be, pretty savvy about writing about them because they're they're heavily tested. The homestead exemption will protect half an acre um, uh, of a primary residence inside a municipality and then 160 contiguous acres outside of a municipality. So, just a little story about someone who knew about the homestead exemption would be O.J. Simpson, right? He might have been uh, acquitted criminally for the alleged murder, but he still was um, civilly liable, right, for wrongful death and for some other claims. So, he could have lost everything. One thing he did, I think, was buy a huge life insurance policy and stuffed a bunch of money in there. But the other thing he did was he bought a huge property, let's say on 155 contiguous acres outside of a municipality in Florida, and that was protected. So even though there was a civil judgment against him, they weren't able to get much of it because most of his assets were protected in this homestead property. So that's kind of a visual that you can help understand, like, why would you, when would that ever come up? Well, if there's a civil judgment against you and they want to take your money, but your money's tied up in your primary residence and it's within the confines of the acreage limit, then that would be a way that you could seek protection from your homestead. So yeah, again, sunshine law, that right of access the public has for governmental proceedings, and then homestead exemption is the protection against judgments for your primary residence for Florida homeowners. Um, Another thing that's pretty important to know is types of laws in Florida, right? There's general laws, there's special laws, and then there's general laws of local application. So a general law applies to the entire state of Florida, right? It's like the drinking age in Florida is 21. That's just a general law that applies to everyone in Florida. A special law is a law that only applies to a specific county, right? And special laws are subject to a referendum or a vote, right? The county gets to vote on it before the law would apply. A general law of local application is not subject to a vote. It's usually based on population. So it's kind of a way that the Florida government can target a particular county without that county voting on the law. If they were to say like all counties in Florida with the population over 1 million have to, abide by this law. Well, that's, local application because it's based on population, but it's not subject to a referendum or vote because it's not mentioning specifically the county, right? Florida has what's known as chartered versus unchartered counties. So a chartered county is a county that has municipalities with home rule power, and chartered counties can enact their own laws and ordinances. They can regulate themselves so long as the laws don't conflict with the supreme law of the state of Florida. Um, so what I mentioned there, home rule power, that's the power of municipalities to, create laws and regulations within that municipality. And municipalities are like within a county, right? Like Dade County would be the Miami-Dade County is the county, and then the municipality of, let's say, Coconut or Coral Gables or Miami could potentially have its own subset of laws. So it's important to know those key phrases: general laws, special laws, general laws of local application, chartered counties, and home rule power. Those are some good buzzwords to know when it comes to Florida law. Another thing, that's tested, and again, there's definitely an overlap between federal and Florida law, but you'll see this access to courts, right? That's a fundamental right where they can't deny someone's access to courts, or they can't make it extremely difficult for someone to access the court system, right? Like paying a high fee or something. There is what's known as the Kluger Doctrine, Kluger, which is a specific case in Florida. And students ask me all the time, do you need to know specific cases? Not really, but it can't hurt, you right? And Kluger or a Kluger style defense is that there's a overarching public necessity that would allow them to overcome strict scrutiny and potentially, uh, deprive them of access to courts or some other fundamental rights, usually for access to courts. Maybe an example would have been during the pandemic, right? Because of the risk of spreading a disease, they could temporarily restrict access to courts because it's an overarching public necessity. That would be what's known as the Kluger Doctrine. Um, and then, one other thing, very rarely tested, but it could come up and you should know about it, would be the discussion about different types of bonds. What a bond is, and we'll talk about this when we do business entities, but a bond, especially municipal bond, is a an instrument that's issued by a municipality where investors, residents or whoever can purchase these bonds. So they're giving money to the government, to the municipality. It's actually a tax-free instrument, and in return, they're going to get their money back over time plus interest. So it's an investment instrument. And there's two types of bonds. There's general obligation bonds and revenue bonds. A general obligation bond is subject to a vote. It's subject to a referendum. It's usually for like a public park or building a school. Right by my house in the Grove, there's a school called Coral Gables High School, and there's a big sign outside that says like this project was funded by general obligation bonds, meaning that like they voted on it, they passed it, and then people were able to buy bonds, and then they're going to get paid back through tax dollars, right? That's why it's subject to a vote. Um, Whereas a revenue bond is a bond that would support like a toll bridge or an airport, and it's not subject to a vote because they're going to get paid back by the revenue of the project. Like a toll bridge is an easy way to think about it. Everyone who drives over the bridge is going to pay a toll, and they're going to use that money collected to pay back the people who paid, bought the bonds that were used to build the bridge. So, kind of a um, in the weeds subject, right? A little bit, but just something that we can note. Um, Go bonds, general obligation bonds versus revenue bonds, rev bonds. But just, reeling it back, I think the most important heavily tested things when it comes to Florida constitutional law would be the Sunshine Law, the homestead exemption, the different types of laws in Florida, general law, special law, general law of local application, understanding chartered versus unchartered counties, um, home rule power, right? The power that municipalities have to enact law or ordinances. Um, those are some key fundamental concepts. And when I say that word fundamental, you think of fundamental rights like access to courts, freedom of speech, freedom of religion, and all that. And you can see how Florida and federal con law, they can definitely tie together. And then I said, con law really has three lenses: the federal lens, the Florida lens, and then the con crim lens. And this one has been tested a lot. Like they keep testing this over and over and over again for the past few years, which, statistically speaking, means that it could definitely be tested again. When I say con crim, I'm talking about Fourth, Fifth, and Sixth Amendment, right? And just in general, I think anyone who's taking the bar exam should know the first 16 amendments to the Constitution. If you're taking the MBE especially, but even in Florida, it's good to know the amendments to the Constitution because most of the amendments are mirrored in Florida, right? Like there's a right to privacy in the Fourth Amendment. There's also a right to privacy in Florida. It's even heightened because it's expressly stated in the Florida Constitution. But that right to privacy, from the Fourth Amendment, it means that, the government can't have an unreasonable search and seizure, right? They can't issue a warrant without probable cause. There is an exception to when they don't need a warrant to do a search, right? Um, and that exception, the mnemonic that I like is spaces, SPACES. These are times where they can do a search without first obtaining a warrant, right? The S stands for search incident to arrest. So if there's an arrest made, then they can, search the person to see if they have any contraband or any weapons or anything like that. The P stands for the plain view doctrine. If the police officer, walks up and sees you have a let's say bag of drugs, right? And it's just out there in the open, then under the plain view doctrine, they would be able to seize that. Um, A stands for the automobile exception. If you're pulled over, they can do a quick inventory search of the car, right? They can, shine their flashlight and see if they see anything. C stands for consent. This one is pretty heavily tested where, if you let the cops come in and say, "Hey, search around, see what you find," and they find something, it's like, well, you allowed them to do that. You consented to it. The E is for exigent circumstances or hot pursuit, right? Like if they're, chasing someone down and in the act of a hot pursuit or, they knock on the door and then they hear flushing. Well, they're probably flushing something illegal down the toilet so they can, maybe open the door and do a search because of the exigency of the circumstances. And then the other S would be a stop and frisk or a Terry stop. And this is, they don't need probable cause. They could have, reasonable suspicion and, do a pat down for weapons. But if they, feel something that gives them probable cause to think that you have some, drugs or contraband on you, then they could continue that search. So that's a really good mnemonic to know for the Fourth Amendment is spaces, search incident to arrest, plain view doctrine, automobile exception, consent, exigent circumstances, and stop and frisk. That's some key things from the Fourth Amendment, right? Um, and again, I told you about the Fifth Amendment and the five things that are stem from the Fifth Amendment. The federal con law ones that are tested would be like the takings clause, due process, but then the criminal ones could be that right against self-incrimination, the right against double jeopardy, and then most importantly, the Miranda rights. The Miranda rights apply when you're in custody, when you're subject to a custodial interrogation. And that means that a reasonable person would not feel free to leave, right? So if you're arrested, you're definitely in custody. And when you're in custody, they have to read you the Miranda rights or recite the Miranda rights before they can do an interrogation. So you have the right to remain silent, you have the right to an attorney. If you can't afford one, one will be provided for you, and anything you say can and will be held against you. And if they do an interrogation without reading you those rights when you're in custody, then there's a strong argument that anything that you admit to will be suppressed from evidence, right? So that's what the Miranda rights are all about. It's about custodial interrogations and your right to an attorney. The key difference between the Fifth and Sixth Amendment right to an attorney is that the Fifth Amendment right to an attorney is when you're in custody, whereas the Sixth Amendment right to an attorney is after they filed charges, after adversarial proceedings have begun. So that's the Sixth Amendment. Sixth Amendment would be the right to a speedy trial, the confrontation clause. You have the defendant has the right to confront witnesses, and then this right to counsel, which, like I said, is different than the Fifth Amendment right to counsel because it attaches after adversarial proceedings have begun, after charges have been filed. And the Sixth Amendment right to counsel is offense specific. So, you know, they it would be just the charge against you, right? You have that right to counsel for the robbery charge because you've been charged with robbery, but that doesn't mean you have a right to counsel for the murder charge if charges haven't been filed yet. Whereas the Fifth Amendment is more general. That's just a general right to counsel for any interrogation. So that's the Fourth, Fifth, and Sixth Amendment. Usually the way this is tested is some scenario where, the Tommy's on the corner smoking something that smells funny, and the cops walk over, and then, they ask to search his body, and they find, maybe a diary, and then in the diary, they find information, and, all this could lead to the exclusionary rule and the fruit of the poisonous tree doctrine, which are, Fourth Amendment considerations. The exclusionary rule means that items that are seized or found or evidence that's obtained in violation of the Fourth or Fifth Amendment will be excluded from evidence, right? They'll be suppressed. And then the fruit of the poisonous tree doctrine means that evidence that's found as a result of unlawfully seized evidence will also be excluded. So let's say the diary that was found was unlawfully seized. And then in that diary, they read an entry that said where you stashed the drugs at. Well, they go and find the drugs. Those drugs would be fruit of the poisonous tree. The poisonous tree being the diary, the fruit being whatever they found. Um, it's a gray area, right? Like I think that there's arguments both ways, and I've seen things kind of change, right? Especially with new governments and different things. But like you know, traditionally speaking, it would be very difficult for them to like seize your cell phone and then go through your messages and then find um, out further information. But actually, I've seen cases where they've done that and it's been upheld. So, always remember when you're writing these essays, the best approach is to take both sides, right? To argue for both sides and then on balance come up with a conclusion. And I think like, the weaker your conclusion, the better, right? Like because the court will likely find instead of this is the definite answer. It's kind of why I like IRAC over the CREAC formula. CREAC is like conclusion, rule, evidence, analysis, conclusion. It's that circular argument. I don't like that because if you start with a conclusion and you're totally wrong or you're, not what the reader believes, then you kind of leave a bad taste in their mouth and they're like, oh, well, here you go. I'm about to write this wrong argument. Where if you do the IRAC, you start with the issue, the rule, the not like they're following you the whole time and then you come to a conclusion and you say on balance the court would likely find, meaning like you're not putting all your eggs in one basket, you're really hedging yourself, and I think that's a smarter approach. So yeah, in general con law is a tough subject, but I think that was a good overview of some things that you would want to know when it comes to federal con law, Florida con law, and con crim law, and they will test con law in some regard. Last administration, they really had two different con law essays. So, definitely be prepared to write a con law essay. And usually what it's going to be is some act or ordinance, right? Some state action. So you want to talk about what is state action. You want to talk about what is standing, right? Like, is it cause and fact, injury and redressability? Is it ripe and not moot? Like these are all some implications that you could begin your essay with, and then you're just going to go through the different constitutional arguments, either justifying upholding the legislation or, you know, questioning and challenging it. So hopefully you guys took something out of that, the con law discussion. Um, and then, I think the hardest essay subject for most students would be real property. Real property is certainly a tough subject. And the reason why is because unlike contracts or torts or con law, there's no like solid blueprint. Like every time you get a con law essay, you're gonna, I said you're gonna write about standing, justiciability, fundamental rights. Like you kind of due process, equal you kind of know where you're going with it. Whereas real property, you kind of just have to take it as it comes. And, it could be a homestead con law real property crossover or a takings con law real property crossover. Or it could be about like a mortgage or about easements or about adverse possession, right? There's just a lot of different ways that they could go with a real property essay. I think important to understand is like ownership of property. How do you own property? Typically, you own property by having title, right? Um, and title is like a position of ownership. You have title. The most, you know, um, I would say the most typical way to have title is by a deed, right? If you have a deed, then that shows that you indeed have title, right? But you could also have title without a deed. Let's say if you have title through adverse possession or something like that, or you could have color of title, which is appearance of title, but maybe it's a defective deed. So then you would have an action to quiet title and different parties would come in and argue, who actually owns the property. There's different types of deeds, right? There's a general warranty deed, a special warranty deed, and a quitclaim deed. The general warranty deed is the most robust, right? That gives you um, the most security that you have no problems in the chain of title. So a general warranty deed has six covenants, right? Six warranties, three present and three future warranties, right? There's the uh, there's the warranty of Seizen, meaning like they own the property. There's the right against um um sorry, there's the general warranty deed has the three present covenants, the one being Seizen, the other being the right against encumbrances, meaning that like there's no easements on the property, there's no um you know uh claims to the property that would make it illegal, right? There's no strange zoning violations or anything like that. Um, and then there's the right of uh, I'm actually drawing a blank right here. I know the mnemonic SEC, so Seizen, the right against encumbrances, and um, does anyone know that? Oh yeah, the right to convey. Thank you. See, I'm not perfect here. It's November. And the right to convey, meaning that you're the person who could transfer the property. So yeah, I had a little mnemonic for that, which is SEC, which is like a football one, and then quiet football game, QFG. And that's why I really like these mnemonics because you see you could get stuck when writing and then you're like, oh, what's the mnemonic? And then it will remind you. So the right of Seizen, the right against encumbrances, and the right to convey are the present warranties. The future warranties are the right of quiet enjoyment, further assurances, and general warranties. You have to bring the present warranty claims at the time that of closing, or else you would have to bring one of the future warranties like quiet enjoyment. Quiet enjoyment meaning that like no one has a claim to your title, right? A lot of times they will have these kind of hybrid contracts, real property essays where there's like some problem with the contract, like it wasn't in writing. Because remember, statute of frauds, contracts for land need to be in writing. But if you now have the closing and then you've conveyed the property, there's this concept of merger where the contract merges into the deed and you can't bring that contract claim after the deed has already been delivered, right? So, you kind of want to think about deed formalities, right? Was the deed attested by two witnesses, right? And then was it potentially was there notice, right? So two important concepts about Florida real property is that Florida is a lien theory state and that Florida is a pure notice jurisdiction. So you could take those two things away from the real property lecture. When I say pure notice jurisdiction, it means that bona fide purchasers will prevail. A bona fide purchaser is a person who takes for value in good faith and without notice. Notice meaning like they had knowledge of someone else's claim on the property, like you know, uh, actual notice or inquiry notice, right? These are different types of notice that like you could potentially have. Actual notice would mean that, you were aware that someone else, um, had an interest in the property. Inquiry notice means that like a reasonable inquiry into the property would have put you on notice. So it's like, um, if someone else is operating a farm on the property, you can't claim you didn't have notice because you should have looked at the property and seen that someone was operating it. And then the other form of notice would be record notice. Record notice, is a type of constructive notice that like it was recorded in the chain of title, and so you were put on notice. But if you didn't have notice and you took for value, then you will be protected as a bona fide purchaser under the pure notice um, jurisdiction that Florida is. And then when I say that Florida is a lien theory state, well, what a lien theory state means is that um, a someone who takes an interest in the property, has a loan. If someone, takes a loan out on the property, the lender doesn't acquire title to the property, they acquire a lien. So the way that plays out is that it won't sever the JTROS, the joint tenancy with right of survivorship. Like I said, I know that property is kind of all over the place, but you need to know the different types of tenancies. A tenancy in common, a JTRS, a joint tenancy with right of survivorship, and then a tenancy by the entirety, which is a joint tenancy with right of survivorship plus the element of marriage. The JTROS, the joint tenancy with right of survivorship, means that there were the four unities: time, title, interest, and possession, and they were all met. So, if two parties have a JTROS, a joint tenancy with right of survivorship, and one were to die, the other party would take over their interest. Whereas a tenancy in common, which is presumed if one party were to die, then their heirs, their descendants would take their interest in the property. So when I said Florida's a lien theory state, it means that if A and B are, co-tenants and they have a JTROS, joint tenancy with right of survivorship, and B takes out a loan on the property, and then B dies, well, the lender isn't going to be able to take title to the property because they just have a loan, they just have a lien on the property. So that's one of the main um, outcomes of Florida being a lien theory state is that that loan on the property won't sever the JTRS. It'll just operate as a lien and it won't give them actual title. So, if you take two things away from Florida, specifically when it comes to real property, understand that Florida is a lien theory state and that Florida is a pure notice jurisdiction. A lien theory state means that the loan on the property won't sever the JTROS, and a pure notice jurisdiction means that bona fide purchasers, the last bona fide purchaser, the subsequent bona fide purchaser will prevail. And the bona fide purchaser is the person who takes for value without notice and in good faith. And then the different types of notice, actual inquiry, and record notice. And these are just a lot of points that you can get if you could demonstrate knowledge of these things, starting from, how was the land acquired? Was it acquired via deed? What type of deed was it? A general warranty, a special warranty, which special warranty only protects the time that the seller had title to the property. It doesn't, you know, um, guarantee anything about the upstream title. And then the quitclaim deed really is no warranties about the property. And then I also said there could be contract claims on the property, right? There could have been a concealment or a misrepresentation or a failure to disclose, right? These things could all come up, but then remembering that the contract will merge into the deed. Florida also recognizes this concept of equitable conversion. Equitable conversion means that the buyer becomes the equitable owner upon the signing of the contract, even before the closing. So in that escrow period, that interim period between the contract being signed and the closing occurring, the buyer will incur the risk of loss. So if you sign the contract and then the property, burns in flames, the buyer suffers that risk of loss. Another um, outcome of equitable conversion means that if the buyer were to die or the seller were to die, their estate still needs to follow through with the closing because the property has already been equitably converted. So, there's some good buzzwords to know when it comes to conveyance of property and title and these different theories. But like I said, they could also test a totally different concept. They could test a mortgage, right? If there's a mortgage on the property. So a mortgage is a loan on property. I'm sorry, a mortgage is a loan secured by property. So if someone is going to take out a loan and then use the property as collateral, that would be a mortgage, right? And in the event that the borrower, which would be the mortgagor, right? The lender is the mortgagee, the borrower is the mortgagor. In the event that the borrower fails to make payments, then the lender, the mortgagee, can institute a foreclosure action on the property. Um, a foreclosure action would be the forced sale of the property to pay back the mortgagee, right? And there could be senior mortgagees, junior mortgagees, etc. And the senior mortgagee is the one who's going to get paid back first when there's that foreclosure sale. In the event that junior mortgagees are not paid back or the senior mortgagee isn't paid back in full, those parties would need to seek what's known as a deficiency judgment against the mortgagor to get payment. Um, Mortgages is a very complicated, I think, subject that you want to know some of the key buzzwords to talk about. And I think foreclosure and deficiency judgment are certainly two of the biggest topics that are tested when it comes to writing about essays. So again, it could be about the deed, it could be about the title, it could be about conflicts of interest that would invoke the pure notice or the lien theory conversation, but it could also be about mortgages or it could be about easements and adverse possession or two other pretty big topics. So easements, there's different types of easements, and an easement is a right of access, right? It's like you're allowed to cross over someone else's property. There's easements in gross and easements appurtenant. An easement in gross is personal in nature. It's like a utility company that has the right to put a telephone pole on your property, right? That easement is owned by the company. It's not owned by like an adjoining property. An adjoining property that has an easement over another property, that would be an easement appurtenant, right? Easement in gross is personal in nature. Easement appurtenant is held by the property and it runs with the land. So if B has an easement over A's land and then B sells to C, well, C is going to have that easement as well if it's an easement appurtenant. Um, Easements can be express or implied. Express is like written and agreed upon, where an implied easement would be, something that just arises out of implication. There's easement by necessity and there's easements by prescription. Easement by necessity arise when one piece of land is landlocked. It's hemmed in by another piece of land and has no access to a public road. Well, that would, you know, give rise to an easement by necessity. An easement by prescription, very similar to adverse possession, right? It's not necessarily exclusive, but it needs to be open, continuous, adverse, notorious, hostile for the statutory period, right? um, it's a 20-year period for an easement by prescription in Florida, where you could acquire an easement just based on your use. And then there's affirmative easements and negative easements. Most easements are affirmative, the right to cross, the right of access. Whereas a negative easement would be like um, air rights or riparian rights, like water rights. Florida doesn't really recognize many negative easements, except it does recognize riparian rights that, prior use reasonable flow theory, where, one neighbor couldn't, put a dam in the river and stop the water from flowing by the other neighbor, right? So, those are six different types of easements that you could potentially talk about in your essay, right? Affirmative easements, negative easements, implied easements, express easements, easements in gross, easements appurtenant, and then easement by prescription and easement by necessity. And then, of course, there could be an adverse possession, which people seem to love. That the time period for adverse possession is 7 years in Florida, and the good mnemonic for adverse possession is ocean, open, continuous, exclusive, adverse, and notorious, right? And obviously hostile and for the statutory period. So, that's a um, adverse possession. Adverse possession is when you actually acquire title to property via squatting, right? Just be a being on the property in a adverse and hostile manner where you essentially take over the property. Um, you could do it with or without color of title. Like I said, color of title is that appearance of title, some deed or document that purports title, and then without color of title means that you don't even have an instrument. And if you're gonna you know, um, acquire property via adverse possession without color of title, then you've had to actually pay the taxes on the property. Again, I think real property is a super difficult subject just because there's so many different directions that they could go with the essay. But again, it comes down to memorization, identifying issues, and stating the rules, right? And then, getting into an explanation and a conclusion, but you have nothing to explain or conclude if you can't identify the issue and the rule. So, a lot of things about real property. And I like to tell people, and I think I would have failed this today, right? But I say, when people come to me and they want to pay my top dollar and say, "Hey, Andrew, I just want to know, am I ready to pass the bar exam?" And it's like the 3 days before the bar exam. The question I usually ask them is, what are the six covenants of a general warranty deed, right? And there's the present and the future, and it's sizen, the right against encumbrances, and the right to convey. And then the future warranties, which would be quiet enjoyment, further assurances, and general warranties. And I just tell people, like, you want to know these concepts in detail and be able to write about them, and you want to be sharp, right? Like, this is November. I wasn't so sharp with them today, but thankfully Andres helped me out, right? So yeah, we want to sharpen up with our real property terminology, and I think that'll be really good for everyone. Um, you know, family law, I think we pray for a family law essay, right? Because that's one of those subjects where, everyone has a family member who's gone through a divorce or knows someone who went through a divorce, and you can kind of just think about what are the factors that went into alimony or went into child support. Um, we have this, mnemonic about, I think, a JV piece, like jurisdiction and venue are the first pieces of it. And it's really the 6 month rule, right? Like, there will be jurisdiction where the spouse has resided within the last 6 months, or where the child has resided within the last 6 months. And then, you're going to have the traditional um, personal jurisdiction and venue, right? Where the parties resided, or where the act that led to the divorce occurred. In general, if there's like a dispute between Florida and Georgia and they want to know who has jurisdiction, it's probably going to be Florida, right? It's a Florida essay. There's also this concept of continuous exclusive jurisdiction, where whoever issued the final um, marital settlement agreement, right, the divorce decree, they'll be able to continue jurisdiction over the case if there's any subsequent matters. And then the P stands for parenting plan, um, the equitable distribution, alimony, child support, um, right? And then I think EWE stands for like everything else, maybe like Esquire fees or, who would be liable for paying. But with the parenting plan, that's how we are going to divide up responsibilities. When there's a divorce, there's can be sole responsibility, there can be split responsibility, there could be some sort of dynamic responsibility where the dad has the sports and the mom has education. Typically there's a constitutional right to be involved in the upbringing of your child. So it's very rare that they're going to award sole responsibility unless one of the parents is acting very detrimentally to the child. Maybe they're a physical or violent or sexual threat to the child, right? Otherwise, we're going to try and have some parenting plan that shares responsibility amongst the parents. Um, the equitable distribution piece of it is how we're going to split the assets, right? We're going to look at marital assets and non-marital assets. Marital assets meaning like what was acquired during the marriage, and we're going to split that up equitably, right? So it could be like, if the mother stayed at home but the father went to work and earned a pension, well, technically the mother is going to get a split of that pension because the thought is, they were a marital unit. And the reason that the father was able to work and earn that pension was because the mother was taking care of you know, the, um, the child rearing duties and things like that. So, you'll see what's non-marital property, meaning like property that either party had before the marriage or, maybe specific gifts or bequests that the parent um, were to have inherited, but typically speaking, we're gonna look for equitable distribution and divide things equitably. Alimony is the concept of what one party may have to pay the other party to keep them, afloat, right? There are different types of alimony. Florida has actually abolished permanent alimony. You could be grandfathered in if you had already received permanent alimony in the past, but they're not going to award permanent alimony today. They'll award some sort of temporary alimony or durational alimony or what's known as pendente light alimony, meaning like during the pendency of the litigation. Um, these are going to be different types of alimony that a party could receive, um, you know, to continue their living standard, right? Like if one spouse was making a lot more money than the other, then they'll probably have to pay alimony to the other party. So, there's durational, temporary, pendente light, like I said. There's also rehabilitational alimony, maybe to like, the mother didn't go to college during the marriage, but now she wants to go get her degree. So they'll try to award that type of alimony. But like I said, they've abolished permanent alimony in Florida. It's not going to be awarded moving forward. You can waive alimony in a um, premarital agreement, right? Like you can waive alimony, but and it's called a prenuptial agreement, but you can't waive child support. Child support in Florida is going to be distributed based on these statutory guidelines, like um, how much what's in the best interest of the child, right? That's really going to be the determinative factor. If you remember anything from, family law lecture today, the best interest of the child, right? That's going to be determinative when it comes to the parenting plan. That's going to be determinative when it comes to child support, right? They typically don't like to use the word custody anymore. They'll use the word time sharing, but you could still use custody. I mean, it's all fine and well, but in general, when it comes to child support, we're going to look at, a litany of factors, right? Like if the child's old enough, um, you could see, and when it comes to the parenting plan, we'll listen to the child. Who do they prefer to live with? Um, and then when it comes to child support, you got to look at, you know, what the child needs, what the child's interests are, and we're really not going to have a modification unless there's a substantial change in circumstances. It no longer needs to be an unanticipated change in circumstance. It used to be that, once the, child support and the final marital agreement, the settlement agreement is administered, they're not going to change it or modify it unless there's an unanticipated change in circumstances, but they've abrogated it recently, so it doesn't need to be unanticipated anymore. It just needs to be a substantial change in circumstance. Like maybe if you want to move the kid very far away, or you say that now the kid wants to become a baseball player and needs to go to Japan to get lessons or something, then you would have to petition the court for a modification. So this, piece mnemonic would be like parenting plan, equal distribution, alimony, child support. The E we said was for like esquire fees or lawyer fees, which typically, you don't pay the other party's attorney's fees, but they could in certain circumstances for an alimony case or a child support case if it's stipulated in advance. And then just understand in Florida, when will they issue a divorce if the marriage is irretrievably broken or um, either party has been adjudicated incompetent for 3 years. So these are reasons why they would award a divorce. Um, they could issue counseling and say, we're not going to award the divorce because, you need to go to counseling. But typically, if you can show that the marriage has been irretrievably broken, they will issue the divorce. Florida's a no-fault divorce state, so it's they're not going to really look into whose fault the divorce was. They're just going to look at, again, the best interest of the child, the continuity of either spouse's living standards when they're determining all these things. So you want to know, the different types of alimony and really understand that child support and the parenting plan, the determinant factor is going to be the best interest of the child. Um, when in doubt on a family law essay, just be reasonable, right? These are the factors the court would consider. How long the marriage has lasted, right? If it's a short-term marriage, a medium type marriage or a long-term marriage. It's, 10 to 20. They've also changed that too. It used to be like 17 years, but now it's under 10 years a short term and 20 years or more would be a long-term marriage. These are, all the factors that come into play with family law. And then, I've seen them test like adoption uh, pretty recently, like when um, uh, when can there be an adoption? Right? Like, if they put the kid up for adoption, that's going to sever the biological parents' rights to the child. Like, the kid won't be able to inherit from the parent anymore or anything like that. If it's a step parent adoption, that's a different circumstance. And in Florida, grandparents do have visitation rights and certain rights. So, just in general, these are some key points to remember when it comes to family law. And I think overall, in general, you should really be focused on the best interest of the child, understanding the different types of alimony, and being able to discuss when a divorce is going to be administered and when there's jurisdiction over the parties, right? That 6 month rule is going to be pretty key and pretty important. And Maria's texting me and she's saying, she messaged me and saying that, Marion, one of my instructors, is really great at family law. Sure, she practices family law. And if you come to my complete courses, I have guest lectures. I never teach family law, but I have, Marion and Emily do family law. I have Rebecca do trust and wills, and I have some great guest lectures that you can hear from. But that was just some of the essential elements that you need to know when it comes to family law. And then ethics. Ethics is a subject or professionalism that's the most heavily tested, even more than common law, because it comes up with other subjects, right? So like if you have a torts essay, it could be like, what claims of action does Tommy have against Susie, and then what ethical issues may arise. Some of the key ethical issues that they test would be like conflicts of interest, right? If, a judge, or I'm sorry, a lawyer had represented a client and now is representing someone adverse to them, right? This would present a conflict of interest. And there's these concepts of um, screening, right? Where you could be screened out because otherwise your conflict would be imputation to the rest of the firm. So, understanding conflicts of interest, um, imputing a conflict, and screening out a conflict are very important. Typically, if there is a conflict of interest, the lawyer, if he reasonably believes that he could, take on the representation without it impairing his legal abilities, he can do that, but he should get signed written consent from the client. That's usually like the best way to get around an ethical issue is to have um, signed written consent from the client. And then sometimes, like if the attorney is going to have an interest in the matter, they would like to have another attorney represent them and then be, get the opinion of another attorney. I think in general, when it comes to these ethical issues, you really want to be as ethical as possible, right? Like really follow the rules of professionalism and say that, this is what the attorney should do because there may be some appearance of impropriety and it would be in the attorney's best interest to seek written consent from the client or to abstain from the representation. Conflicts of interest come up a lot, and then certain duties that the attorney always has, right? The duty of candor, the uh, duty of confidentiality, right? It's important to understand the difference between duty of confidentiality and attorney-client privilege. Attorney-client privilege is an evidentiary rule, and that's for, between the client and the attorney. Words, disclosures that are made to the attorney from the client are going to be protected and, not subject to discovery. Whereas the duty of confidentiality is much broader than attorney-client privilege. The duty of confidentiality refers to any information that is communicated to the attorney regarding the representation. So if, the attorney represents client A and then A's friend B sends the attorney an email. Well, that email, if it's related to the representation, would be protected under the duty of confidentiality, even if it wasn't protected by the attorney-client privilege. Duty of confidentiality comes up when, the attorney, is being asked to reveal information or they do reveal information that was confidentially uh, given to them. And, sometimes they can breach this duty of confidentiality. Let's say if the client is trying to use the attorney's services to commit fraud or crime, right? The crime fraud exception, then, they would be able to disclose that to the judge and try to uh, stop the representation and withdraw from the case. So, some of the big ones, like I said, the duty of candor, the duty of confidentiality, the conflict of interest definitely comes up a lot. And then they also talk about, oh yeah, duty of decorum, right? Duty of candor is like to be truthful and not file frivolous claims. And then the duty of decorum is when you're inside the court, not to be, disrespectful and, uh, you know, be uh, interrupt the judicial process. And then, of course, attorney's fees, right? Attorney's fees need to be reasonable. You can't charge an outrageous amount for your representation. And you also have to have this duty of competence. You can't take on representation if you aren't competent. You can become competent via study or, by aligning with another attorney who is competent, but you can't take on representation that you're not competent to take on. And, supervising attorneys, they have a duty to make sure that um, their junior attorneys, the attorneys that they supervise, aren't violating the rules as well, because they could be held liable for, failure to properly supervise. When it comes to attorneys' fees, um, referral fees are generally disfavored, right? We don't really allow attorneys' fees in Florida unless they get informed consent from the client and they participate in the representation, right? Like if Tommy refers a case to Johnny and Tommy's going to get part of the representation fee, Tommy does need to be involved in the representation of the case in some regard. And then certainly they test contingency fees. Contingency fees, it's important to understand they're not allowed in criminal cases and domestic cases. Like you can't take a contingency fee to represent someone in a divorce, but you certainly could take a contingency fee, let's say in a personal injury matter, if you are, um, you know, representing someone in a car accident. And if they win, you're going to get a percentage of the winnings. Now, contingency fees, again, you need to get the informed consent of the client, and the client needs to be informed about how the split will occur. And then when the award is given, they need to get that final calculation of the contingency. So again, the key point to the contingency fees is it's disallowed in domestic cases and criminal cases, and there needs to be some uh, consent on how the contingency fee will be paid out, and then when it's finally paid out, some sort of calculation. I mean, ethics, if you took the MPRE, it's not like as in-depth of a subject, right? Like it really just comes down to like writing, 3 paragraphs maximum, sometimes one, sometimes 2 paragraphs, really describing what the attorney's ethical obligations are. And when in doubt, you should write that, hey, the attorneys should be careful here. They should probably avoid the conflict of interest, or if they can't, they should get the consent and things like that. And they need to be competent. They need to follow the duties of decorum and the duties of competency and the duties of candor, right? So again, I know I really glossed over some things today. It was a lot, and I stumbled a little bit here and there, but ultimately, these uh, key points are the things that you really need to know and focus on. Just real quickly, looking at the PowerPoints that we have, see if we touched on most of these subjects. Um, right, for Florida, sunshine law, homestead exemption, general, special, general law of local application, chartered counties and home rule power, enacting a law or ordinance in Florida. That I didn't mention, but like, yeah, the single subject rule, the fact that it needs to have a clear subject and title. It needs to be related to the health, welfare, and morals of the people. And as always, it can't be vague or overbroad. Vagueness means that it's unclear what's being punished, and overbreadth means that it's punishing more than it's intended to be. This one too tested a lot, and I didn't mention it, but separation of powers. The legislative branch, the executive branch, and the judicial branch, like they can't, give the mayor the capacity to determine whether or not someone has violated the law, right? The mayor is an executive figure, so you can't give him judicial powers. That's something that's kind of hard to see. When I think of separation of powers, think of like encroachment, entanglement, entwinement, usurpation, right? This stepping on the toes of the other branches. For federal con law, right, standing, we talked about injury, causation, redressability, state action, justiciability, right but not moot, due process, substantive and procedural, right? Substantive meaning rights are being violated, procedural, notice and hearing, fundamental rights and scrutiny levels. We talked about the Fifth Amendment and the 14th Amendment. And then I said, yeah, Commerce Clause, Dormant Commerce Clause, privileges and immunities, meaning that you can't treat out-of-staters, you can't discriminate against out-of-staters. Commandeering Clause, encroachment can come up with um, the separation of powers, state sovereignty and sovereign immunity. Again, not super heavily tested, but it could be, right. Sovereign immunity meaning like you can't sue the state. Um, like an individual can't sue the state, but they could potentially sue a state actor in their official capacity, right? And then, if Florida were to sue Georgia, the Supreme Court would have jurisdiction over that. And then state sovereignty, that's that idea of uh, the anti-commandeering, right? Like where the states, it's a lot like the home rule power, where municipalities can enact laws that don't conflict with the state of Florida. The states can enact laws that don't conflict with the um, government, right? The federal government. We talked about the Fourth, Fifth, and Sixth Amendment. They can certainly test about the different types of crimes: murder, arson, conspiracy, inchoate crimes, right? Attempt and solicitation will merge, but not conspiracy, theft crimes, and other crimes. I put this link here. I really like this guy a lot. Um, Hornsby Law, I think it's Richard Hornsby or Robert Hornsby or something, but he lists all the different you know, yeah, Richard Hornsby, all the different crimes in Florida. I really like this website. It talks about the difference between first, second, and Florida even recognizes third degree murder, right? I mean, you could be called to write about these crimes, so you should understand them. I don't really go over them so much in the essentials course because, we all know murder. Murder is going to be like, um, depraved heart murder or intent to inflict great bodily harm or felony murder. And then, of course, there's, common law murder, which is like premeditated, malice aforethought, cold blood murder. And then Florida doesn't really distinguish between the theft crimes so much, like, larceny by trick or um, larceny, right? They're just all under the theft crimes. Here's a really good definition of the Sunshine Law. All meetings at which public officials discuss public business must be noticed and open to the public. Records of such meetings must also be accessible to the public. The public has a right to government information of the Florida Constitution. And there's an exception to the Sunshine Law, meeting requirements for unplanned meetings between state legislators. This applies to meetings between two state legislators or one state legislator and the governor, right? Straight from a model answer. I really believe in looking at the model answers, trying to memorize the language that is used because, clearly they like that language. So if you can recite that language, you could definitely get points. When they say this exception, it's like, if two legislators, meet in a bar and have a drink and, just have a conversation about the football game, right? That wouldn't implicate the Sunshine Law. The homestead exemption we talked about protects your primary residence, the owner and their dependents, right? And their spouses, minor child, half acre inside municipality, 160 acres outside municipality. Here, this slide I didn't really talk about, but enacting a law, adequate title, an enactment clause related to the health, safety, welfare, morals of the people, not vague or overbroad. Single subject, meaning they can't pass a law that's like a curfew law and a law about, drinking and driving, right? It's got to stay on one subject. And then to actually, pass the law, it needs to be read three times into both houses. That's called bicameralism and the governor's signature. Florida does not recognize the pocket veto, right? So if the governor doesn't sign it, it does not become a law. That's a little bit different than federal. We talked about this general, special, general laws of local application. Some other things, access to courts, right? They can't abridge that unless we have the Kluger Doctrine. It's necessary and compelling public interest. This right here, any changes to the Florida Constitution must be approved by a vote of 60% of the people voting in the matter. That's why, I think it was abortion and marijuana. They were on the ballot and they both got over 50%, but they didn't pass, and people didn't understand why. It's because they were trying to amend the actual Constitution. And then special legislative sessions, when the governor calls a special legislative session, they only can, convene and talk about the reason why the governor called it unless they get two-thirds consent from both houses. Fundamental rights, strict scrutiny, takings clause we talked about, eminent domain, the second president of the United States. Does anyone know who that was? Who's the second president of the United States? Everyone knows the first. I feel like people don't give the second enough credit. Um, let's see. I like the second president of the United States compared to the other ones. He was against slavery, which I think is pretty cool. That would be John Adams, and then his son John Quincy Adams was also. They're the only two of the first like 10 presidents who didn't own slaves. So I don't know much about John Adams and John Quincy Adams, but I like that. Real property, we talked about different types of deeds, and you want to know the different covenants, uh, deed formalities, right? Attested by two witnesses, accurate description of the land, and be properly delivered. Florida is a pure notice jurisdiction. Marketable title, meaning like, there's no strange ordinances. It wasn't acquired by adverse possession. It's not subject to a right of first refusal or something like that. When I took the bar in 2017, they asked about a tax deed. No one knew what that was, right? They tend to do that, just like throw crazy things at you, and you just want to take it in stride. So a parcel of real property becomes eligible for a tax deed when property taxes become more than 2 years past due. So if one of you guys want to look on the internet and see if there's any properties that are eligible for a tax deed, that's a way to kind of snatch up a property by just paying the taxes on the property. Um, they don't really test so much about these fee simples, life estates, but like if you have a life estate, then you have these duties, right? um, not to commit waste, and waste could be like actual or permissive or ameliorative waste. Um, and we talked about different tenancies, tenancy in common, JTROS, tenancy by entirety, covenants and equitable servitudes. These are promises tied to property. Covenants are remedied by monetary relief. Equitable servitudes are remedied by, equitable relief by like you're being forced to do something. And then this right here, this could be a whole essay, right, about landlord tenants. I didn't really talk about it because there's so much in real property, but landlord tenants, it's just like, what are the duties of the landlord? They have to deliver, the actual and legal possession of the property, and they have to, conform to the duties of habitability and quiet enjoyment. And then the tenants have to, pay rent, not commit waste, right? You should definitely understand these different concepts between landlords and tenants. Um, there's tenancy for years, a periodic tenancy, tenancy at will, and a tenancy at sufferance, which is basically like a holdover tenant. We talked about easements, right? All the different express, implied, by necessity, prescription, appurtenant, easement and gross, negative easements. Adverse possession, again, we talked about 7 years for adverse possession, 20 years for prescriptive easement. And then again, the homestead exemption we talked about in con law. Florida's a lien theory state. And right, the risk of loss is going to go to the purchaser based on that concept of equitable conversion. Um, I'm telling you, real property can be pretty tough, but hopefully you took some things away from today. If anything, it's a pure notice jurisdiction and a lien theory state. Let's see whose PowerPoint this is for family law. Yeah, okay, so here's the one that were made by Marion and Emily. And like Maria said, they do a way better job at family law than me, but so many different subjects coming up, like jurisdictional issues, divorce, marital agreements, equidistribution, alimony, child rights, adoption, parental responsibility, equidistribution, alimony, child support, right? They did a real good job with this. It's a no-fault divorce state, right? The 6-month rule, really important. Prenups and postnups, um, right? And you can't limit or preclude child support in a marital agreement, right? That's a alimony, sure, but not child support. And an equitable distribution. Like I said, these are the factors like contributions, interruptions of their career, circumstances, length of the marriage, marital property versus non-marital property, marital property is acquired during the marriage, right? A lot of cool things about this is a really good PowerPoint. Alimony, again, it's available to either spouse. Um, and again, these are all the different factors. Right now, you can even consider adultery when determining alimony. Pendente light, bridge the gap, rehabilitative, durational, right? We don't do permanent alimony anymore. Temporary, bridge the gap, rehabilitative, durational. They've abolished permanent alimony, but you could be grandfathered in. Um, right? If you're going to seek modification, there needs to be a sufficient material involuntary uh, change, right? Material change. It doesn't need to be unanticipated anymore. Um, time sharing, right? Like we don't really use the word custody anymore. We use that word time sharing. And again, it's rare that they have no right to shared responsibility because you do have that constitutional right to be involved in the upbringing of your child. These are the right statutory guidelines for uh, time sharing and parenting plan, things like that. Relocation, right? They would need to petition to the court if there's going to be a major relocation. Always talking about the best interest of the child. You should definitely know this, that Florida's adopted the UCCJEA, the Uniform Child Custody Jurisdiction Enforcement Act, right? You could definitely learn more about that. Child support cannot be waived in a marital agreement. You can't really, if you're going to depart more than 5% from the statutory guidelines, then you need to show written findings and justification. And then adoption, right? Uh, anyone can be adopted, um, and you have to, do some reports, and it'll terminate the parental rights unless it's like a step family adoption, right? You can see how you structure essay jurisdiction, prenup or postnups, divorce, equidistribution, alimony, time sharing based on the UCCJEA, best interest of the child is the main thing, and then potentially adoption. It'll terminate the prior parent-child relationship and establish a new parent-child relationship. Um, yeah, death, annulment. So the difference between annulment and a divorce, an annulment is like I think of like annulment like rescission and divorce like expectation damages. Annulment pretty much says that the marriage never even occurred, right? Really great PowerPoint. And if you come to my complete course, I'm definitely going to have Marion and Emily present that again. And then, finally, last thing, and I appreciate you guys all hanging out with me. I'm actually a Philadelphia Eagles fan, so my team is playing right now. That's how dedicated I am to this. Um, the last thing is ethics, right? And when it comes to ethics, right? This is a statement. If you read my book, I write this like 4 times in my book because I think it's just a great way to start a ethics discussion. The ethical duties of Florida lawyers are outlined in the decisions of the Florida Supreme Court, the Florida Rules of Professional Responsibility, the ideals and goals of professionalism, the oath of admission to the Florida Bar, the creed of the Florida Bar, and other documents. All Florida lawyers must comply with the professional responsibility obligations and are subject to discipline for noncompliance. If it was me, this is the first thing I write when I start the test. I just write this down out of memory, and then I copy and paste it to start every ethics section. Right? We talked about referral fees. They have to be reasonable, and they have to right get the writing signed by the client stating the terms of the arrangement. Um, the business transaction rule, right? They can't engage in a business transaction with a client unless they get the signed writing and they're informed of the desirability of seeking independent counsel. Conflict of interest talked about a lot, right? Like understand screening and imputing the conflict, and then contingency fees not allowed in domestic matters or in criminal matters. And right, if it's a contingency fee, they need that final calculation, and the lawyer can't charge an unreasonable fee. Yeah, those are some of the key points. And then, yeah, an unrepresented party, you can't like if someone is represented, you can't go up to them and talk to them without their attorney being there, pretty much. And then, yeah, I didn't mention advertisements and solicitation. You can only solicit if you have a family or prior professional relationship. And then for advertisements, it can't be, material, misleading, or false. We talked about the duty of confidentiality. It's much broader than the attorney-client privilege. And yeah, curiosity will conquer fear even more than bravery will. Yeah, those are some of the key things to talk about. I know this was a lot in one course, but I wanted to get through all the essay subjects so we can spend the next 2 classes talking about Florida multiple choice. I encourage y'all to submit essays so that we can return them for grading. Um, yeah, I know that it was a lot of information, but hopefully you took some key things today. If you were writing furiously, then you could go back, refer your notes. This recording will be added to the classroom so you can rewatch it. But just generally, hopefully you got the wheels turning a little bit when it comes to these subjects. And then, in December, January, February, we'll go over all these subjects in deep detail. But I really appreciate everyone for hanging out with me on this beautiful Monday evening. I'm going to stop this recording.